All right, good morning. Thank you for joining us today. My name is Caitlin Fallon Wildoner. I am a Social Security disability attorney based in Florida. And today we're going to talk about how you can file a Social Security request for hearing. First, before we get started, I do want to make sure to mention that today's webinar is not considered legal advice. Everybody has a different situation. It's impossible for me to know what your situation is without having a conversation with you. So today is general discussion about how to file that request for hearing. At the end, I will provide my contact information. So if you do have questions about filing a request for hearing or really anything else having to do with the Social Security disability process, feel free to reach out and contact me. That is a way that I can give you advice specific to your situation. Today, again, is just a broad overview of filing the request for hearing for Social Security disability benefits. So today, we're going to talk about some of the common reasons that exist behind SSI and SSDI denials. We'll cover how you can file your own request for hearing before an administrative law judge or an ALJ. That's kind of the lingo. We'll talk about what Social Security will do once you file your appeal or your request for hearing. It's the same thing. It's a request for hearing is an appeal. And then finally, as I alluded to, we will talk about how an attorney can help you with your Social Security disability claim. A little bit about me. I am the founding attorney of Beacon Disability, PLLC. It is a Florida-based law firm. However, we handle only disability cases, and therefore, as our disability cases are an administrative practice area and it's based on federal law, we are able to assist clients in all 50 states. So if you do have questions and you're not in Florida, you can feel free to reach out to me for questions answered. Again, we exclusively practice federal administrative disability law, and therefore we can assist clients in all 50 states at agency level SSDI and SSI matters. We do not handle any federal Social Security cases. First, I want to cover the Social Security 5-step evaluation process because understanding that gives you a basic understanding of what Social Security is looking for and why they may have denied your case at initial, and then now if you're watching this at reconsideration, and what you might be able to do going forward to kind of help. So first, when evaluating a case, the first thing Social Security looks at is, are you engaging in substantial gainful activity? And this year for 2022, that is earning less than $1,350 gross in a month. I'm sorry, that earning more than that is considered substantial gainful activity. So for SSDI and SSI, you've got to be earning below that. If you're earning above that, Social Security won't go any further. They'll say you're engaging in substantial gainful activity, and they'll deny the case right then and there. The other thing is, even if you aren't earning that much a month, if you're working at least 20 hours a week, then Social Security will again look at it, say, nope, you're engaging in substantial gainful activity, and they'll deny the case. Okay, so if you get through that, if you are not engaging in substantial gainful activity, Social Security then moves to step 2. Do you have any severe medically determinable impairments? And to find that out, Social Security reviews your medical records. They look to see, do you have any severe medically determinable impairments? Is there any condition that gives you severe limitations based on your medical records? If not, Social Security stops the evaluation there. They don't go any further. They say you don't have any severe impairments. You cannot be disabled according to our rules. If you do have severe impairments, then they move to step 3 and they look at the blue book of listings to see, okay, based on your medical records, your impairments, do you meet at least one of these listings in the blue book? If yes, then that's where the evaluation stops. And this time, when the evaluation stops, you get approved. If you don't meet a listing, then Social Security moves to step 4, which is, can you return to your past work? In evaluating whether you can return to your past work, Social Security creates a residual functional capacity for you. Basically, they review your medical records and they determine physical and mental limitations that prevent you from doing certain things. And they look at your abilities, what you are able to do, and they create that residual functional capacity, or RFC. Using that RFC, can you go back to your past work? And there's 2 different ways. Can you go back to it as you performed it, or can you go back to it as generally performed? Sometimes people can only do one or the other. Sometimes people can do both. It depends on your medical records and your situation. If you can go back to your past work. Social Security stops the evaluation. They say, okay, you can go back to your past work, so you're not disabled. If you cannot go back to your past work based on the RFC that they've given you, then they look to see, okay, is there any other work that you could do with your limitations, your abilities, and your RFC? If there is other work that you can do, Social Security, in this case, they stop the evaluation no matter what. It either is a favorable or a denial. If you cannot engage in any other work, it is often a favorable decision. If you can engage in other work, it's often a denial, and Social Security will say, no, you can go do these types of jobs. Common reasons for disability denials. The most common one is that you're not disabled according to their rules. And I should say that's the most common one that we can help with. Typically, that means that after looking at the medical records, Social Security doesn't think there's enough there to prevent you from returning to your past work, returning to other work, and that you don't meet one of the listings. Other common reasons specific to different programs for the SSDI, one of those common reasons for an SSDI denial is you don't have enough quarters of coverage. And a common reason for SSI denial that's specific to SSI is if you have too many assets or too much income. So I'm not going to go into it super in depth here, but here's kind of what Social Security considers too many assets or too much income. So asset restrictions for SSI, you cannot have more than $2,000 in assets if you're single and more than $3,000 in assets if you are married. As you can see, there is a slew of things that it does not include, but generally speaking, it will include anything. I usually tell clients it doesn't include one house and one car. So if you have one house or one car that pushes you out of eligibility, you can take that back. It's kind of everything else. So as you can see, there's a lot more than just one house and one car that are excluded from that 2,000 and 3,000 income or asset restriction, but that's kind of a general speaking. Income restriction, there's a lot of rules surrounding income restrictions. What I will say is there's that website there that links directly to the Social Security Administration. I would go there and check that out if you have income. There's different rules based on earned income and unearned income. So I would go to that website if you have questions about what kind of income restrictions there are for SSI. You can also always call SSI directly. And when they try to do that SSI application with you over the phone, they'll ask about your assets and your income. And if you're not eligible based on your assets or your income, they'll usually be able to tell you right there, and they'll follow it up with a letter in the mail a few days later. SSDI, another common denial is if you don't have enough quarters of coverage. In order to qualify for SSDI benefits, you have to have disability insured status. And in order to have that disability insured status, you have to have earned at least 20 quarters of coverage in the last 10 years. So if you call in, you'll hear me say, have you worked 5 of the last 10 years? That's the most broad and general way I word it. And if you haven't, then we kind of dig in deeper into whether or not you might have enough quarters of coverage. But if you have worked 5 of the last 10 years, generally that's going to be enough to push you into eligibility for SSDI. You can earn up to 4 quarters of coverage a year. It makes sense, 4 quarters in a year. And for 2022, for every $1,510 you earn 1 quarter of coverage. You can't earn more quarters of coverage than there are quarters in a year, but you don't have to work each quarter and earn that $1,510 in each quarter to get the quarters. If you earn your 4 quarters of coverage in the first 3 months of 2022, then that's great. You still are earning money and paying into the system for the rest of the year, but you've earned your 4 quarters of coverage for that year. Exceptions do apply to the quarters of coverage, the 5 of the last 10 years. Those do apply for, especially for cases under age 31, but certain other cases as well. All right, here's the most common denial that we can help with if you are not disabled according to the rules. As I alluded to before, there is what is called a blue book of listings. There are actually 2. There's one for adults and one for children. They each have different rules, restrictions. Each listing has different requirements that an individual must meet. The listings all heavily rely on medical evidence. You have to have supportive medical evidence, often objective medical evidence, to meet the listings. In addition to the listings, again, as I mentioned before, Social Security does create an RFC. You can help them create that RFC by helping to make sure that the record supports your true RFC, But generally speaking, Social Security looks at the medical records to determine, do you meet one of the listings? And if not, what's your RFC going to be? So some fast facts on reconsideration denials, which is what you've got if you are filing a request for hearing. Social Security, I believe at this point, they have reinstituted reconsideration in all 50 states. I know for a while, some states, you would do the initial application, you'd get denied initially, and you could immediately request a hearing. You could skip the reconsideration level. But I believe at this point, all states have reinstituted reconsideration. So if you are at this stage, you're appealing that second denial on the same application. And usually that denial will say that something to the effect of, we decided our first decision was correct. So that's how you can really confirm that you are appealing a reconsideration and that you are requesting a hearing before an administrative law judge, not a reconsideration. So as a claimant, you have access to the back end of the system. You can see the online status update. I have clients that can see it. It sounds like it's kind of a percentage bar that it'll say, okay, we're 75% of the way done. I have heard from clients that sometimes that slides backwards. It'll be up to, 82%. And then all of a sudden it's back at 68 and they want to know why. I'm not sure. It could be that they have requested more medical records or that they found more medical records. And so then it kind of slid it back into a different percentage. I don't have access to that part of it. My back end of the system as an attorney looks very different from yours. And we each have access to different things on the back end. We actually access the back end through different ways. So your system that you can see is very different from mine. So I don't have access to that. Even if I'm your attorney, I don't have access to that. You have access to that. It's something that you have to create in your My SSA portal. So that is, you can kind of check the status of your claim. I do get clients who will call or email and say, hey, I see that I've been denied as of yesterday. What do we do next? Well, we wait for the letter to make sure that it's a true denial and what we were expecting, not some crazy nonsense. So that's the next step, is that you do receive a mailed decision letter. Generally, it's a form letter. There's not a whole lot of information on there about what Social Security thinks or doesn't think. It'll usually show the doctor's reports that they pulled. It'll usually list the conditions that they evaluated. And it'll usually provide a very form response on why they think you're not disabled. You can go back to work as a waitress, or you can adjust to other work that requires less physical effort and minimal time and training, things like that. The letter will also say you do have your 60 days to file an appeal. If you are disabled and unable to work, and Social Security says you are not disabled according to their rules, you can appeal. However, as I've mentioned before, medical evidence is key. Medical evidence is very important because while Social Security may think you are the most upstanding and trustworthy individual on the planet, they still need to see the medical evidence backing up what you're saying your limitations are. So medical evidence is very, very important. There are 3 ways that you can file a request for hearing, and right now there's only 2. The most popular way is you can file it online. This used to be, not even many years ago, but just a few years ago, strictly reserved for attorneys. In recent months, and I think COVID probably has something to do with it, anybody can file their request for hearing online. So if you are unrepresented, you can file your request for hearing online by making sure you're on the Social Security Administration's website and searching for that request for hearing. I say this in all my webinars. I think don't put your information on a website other than ssa.gov unless it's an attorney that you have already spoken with and were expecting, okay? So make sure anytime you're providing your personal information that it's on the Social Security Administration's website, not a different website, unless, of course, you're working with an attorney and they have sent you a link to submit your information to them electronically. That's how we do it. That's how I know a lot of law offices do it, especially after COVID, where they will send you a link to an intake form. They'll send you a link to an update form. And in those cases, as long as it's coming directly from the office and you know to expect it, it's generally okay. And like I said, I tell all of our clients, when they can expect to get that from us. So that way they know, okay, this is a safe website. I can put in my personal information here. If you don't want to do it online, you can also do it the old-fashioned way. You can submit it via the Postal Service, and you do that by using the form HA501, which is that request for hearing before an administrative law judge form, and an SSA 3441, which is an adult disability report, which will outline all of the doctors that you've seen, your medications, things like that. The third way, which is currently not an option due to COVID-19, they are talking about reopening our offices kind of in phases. So I don't know when, if or when I should say, this option will become available again. But historically, you were able to file a request for hearing in person prior to March 16th, 2020, which today is March 16th, 2022. So it's been 2 years since you have been unable to file a request for hearing in person. And like I said, Social Security has made strides towards fixing that, in part by making that online appeal option available to everyone. Here is that SSA HA 501. The request for hearing. As you can see, you'll want to put in your personal information, your name, your social. There is a claim number on most reconsideration denials. It will have a claim number. Go ahead and stick that in there. And what it says is claim number if different. That just means if it's different from your social. A couple years ago, Social Security, the claim number was your social. Now they've kind of shifted and tried to make the claim number a little bit more prominent. So if you do have a different claim number, go ahead and put that on there. And then you'll want to say why you request a hearing before an administrative law judge. Commonly, it's because you're disabled and you're unable to work, and the agency keeps saying that you can go back to work. You don't need to go into detail and write pages and pages. As you can see, there's not a lot of space there. So it's just a short and sweet, why are you requesting a hearing before an administrative law judge? Online, it actually restricts the number of letters and symbols and whatever you can put in there. I think it's like 220 or something like that. So it's meant to be a very short and sweet statement as to why you're requesting a hearing. Then it will ask you if you have additional evidence to submit. If you have an attorney, this is all handled kind of by them. If you have additional evidence, then you can go ahead and say yes and include it. If you don't have it there, if you have it and it's coming, you can include the name and the source. The other thing that you can do is say, yes, I have additional evidence to submit because I've seen more doctors. And then you can put that in there and the next form that we'll talk about as well. Finally, it will ask, well, not finally, but the last kind of big question is, do you want to appear at a hearing? I will generally recommend 99.9% of my clients request to appear at a hearing. You can always withdraw that later. But if you come out and say, I don't want to appear at a hearing, just make a decision based on the record, then that's what they will do. And it's a lot harder to kind of withdraw that request than it is to withdraw your request to appear in person. And then finally, you'll go ahead and you'll put all your contact information there. Again, if you have an attorney, this is usually something that they will do as long as you hire that attorney in enough time to allow them to complete this form. Here's the disability report appeal. This is the other form that gets submitted with the request for hearing. And as you'll see, you'll want to put in your information. You can give the name of a third party that Social Security can contact about your condition. And then you'll want to say if you have any new conditions. You'll want to list them out, including when those new conditions started. You'll want to list out any change in conditions that you've got, including when that change started. And then you'll include information about your updated provider information. Have you seen more doctors? Have you seen the same doctors that you had been seeing again? Have you been hospitalized? Have you had a procedure done? Have you had imaging done? What's been going on since you last provided that update to Social Security? That's what you'll want to provide in this disability report appeal. Here you'll see the provider information. You'll want to put the name, their address, their phone number, and then you'll want to include the dates of treatment, so the very first time you ever saw them. This is not the first visit since you last told Social Security about it. It's the first visit ever. And that helps to ensure that the file is truly complete. You'll want to include the last visit, which is the most recent visit that you have with this provider. And then if you have a future visit scheduled, you can include that too. And as you'll see, there's office/clinic/outpatient visits. Then there's emergency room visits if it's a hospital or an urgent care. And then there's overnight stays if it's a hospital, rehab facility, anything like that. You'll want to say what types of conditions were treated or evaluated. And then you'll also want to say if you received any type of testing from that provider. Additional information in that adult disability report is going to be your current medications. You'll want to include the name of the medication, your dosage, who prescribed it, why do you take it? Is it an on-label or off-label use? You know, all medications have a certain FDA approved use. However, not everybody is taking that medication for that use. So I will often double check with clients to make sure, are you taking this for your nerve pain? Or is there another reason why you're taking it? You'll also want to include if you have any side effects from the medication. Sometimes if you have a lot of medications that you're taking, it's hard to tell which medication is causing which side effect. And in that case, it's okay to make that notation to say, I don't know which is causing these side effects, but here are the side effects that I notice after I take my morning meds, my afternoon meds, my nighttime meds, whatever it is. You don't want to put side effects that the doctor tells you might have. You want to put your actual side effects. What are you actually experiencing? If the doctor tells you, well, this might cause drowsiness, so you want to take it at night, but it doesn't cause drowsiness in you. I've personally, and I've had clients take medication that's supposed to cause drowsiness, but it actually does the opposite, where it really winds you up. So, you know, it can come as kind of a shock the first couple of times you take it. You're like, why am I not falling asleep right away? The doctor said this would make me drowsy. It's not, it's doing the opposite. So that's why it's important to put your side effects, not what your doctor said might exist or what might be on the side of the bottle. Okay. You'll also want to include if there's been a change in activities since you last told Social Security about your activities. This can happen if your condition significantly worsens. It can also happen if your condition significantly improves. If you had surgery and you went through the physical therapy and now you feel better, almost better than you did before all of this started, it's okay to say that, because again, Social Security is not going to approve a case where you're not disabled anymore. So if there's been that change in activities, let them know. Again, if you have an attorney, talk to them about that. Social Security will also want to know if you have any changes to your work or your education. I have this happen where sometimes I'll get all the way to hearing and a client tells me, oh yeah, I'm about a week away from getting my bachelor's degree. Wish I had known that. So you've got to keep Social Security updated on that. You've got to keep your attorney, if you have one, updated on that. And again, that is largely focused on the work. If you're working, then kind of going back to that initial evaluation, that 5-step process. Are you engaging in substantial gainful activity? Yes or no? So that's really the driver. But if there are changes to your education, Social Security would like to know that as well. In addition to the request for hearing form and the adult disability report appeal form, you'll want to include an 827, which will allow Social Security to request your updated medical records. If you have an attorney, that's something that they do. But if you don't, you'll want to make sure that Social Security has the ability to do that. So next steps, once you file your request for hearing, Social Security will schedule a hearing as soon as possible. Right now, and this truthfully changes from month to month, day to day, year to year. Right now, at the time of this recording, it's anywhere from 6 months to 18 months or longer. When I first started doing this in Florida, it would be at least 24 months from the date you requested a hearing until you actually got the hearing. They have significantly cut down that time. Sometimes I'm getting hearings scheduled a couple months after I file the request. So that way, you know, they're kind of scheduled 6 months from when we file it, 6 to 8 months out. It just depends. It depends on where your case is, as far as which hearing office it is, what the backlog is, whether it's been assigned to a judge, who the judge is, what the judge is looking for, things like that. Social Security, yourself, your attorney will want to pull updated medical records. Once those updated medical records are in, a judge and her or his staff will review the case. You, the judge, your attorney, a vocational expert, possibly a medical expert, will attend the hearing. And after the hearing, you will get a written decision in the mail. This decision will look very much unlike any decision you've received from Social Security before, as it's very long. They tend to be anywhere from, some are as short as 7 pages, or I guess they could be even shorter. But that's, I think that, you know, the shortest that I've seen is probably 5 to 7 pages. And sometimes they go up to 20 pages or more. They are very detailed. You'll see the other 2 decisions were just that kind of half-page typewritten response as to why you're not disabled. This will be longer. This is in depth and detailed. So that's why it takes a little bit longer for the decisions to come out as well. All right, as I promised, I'll talk about how an attorney can help you briefly. We review your documents for accuracy and completeness. We can't fill them out for you. We don't know what you go through on a daily basis. You know that. You know that better than anybody. You're living it. We can help you fill that out. We can review that for you, but we can't fill it out without your input. We need to know from you what's going on. So we can review those for accuracy. We can review them for completeness. We can also discuss with you what Social Security is looking for in those requested forms. What do they use these forms for? What's their purpose? What do they want from you? We'll work with you to provide relevant updates to Social Security throughout your claim. If you've ever tried to call Social Security, you may be on the phone for an hour, 2 hours. We don't have often, sometimes we do, but not often, we don't have a secret backline into getting somebody on the phone right away, but we do have other ways of communicating with the agency that can be helpful. We can provide guidance on what correspondence from Social Security actually means. If they're sending you to a consultative exam, if they denied your case, if they're asking for more information, we can help you explain what that means. As I mentioned before, if you hire an attorney ahead of time, we can file necessary appeals. Now, if you call an attorney and say, I've got 60 days to file this appeal, and by the way, today's day 59, the attorney might tell you to file it yourself and let us know once it's been done. We do need time to file appeals, but if you call an attorney with enough time, we can file necessary appeals for you, again, with your permission. We do review your medical records. We discuss them with you. This is a big benefit to having an attorney. Not everybody reviews their medical records as an individual patient. So that's kind of a big part of our job as the law firm that's working with you to kind of highlight things that work well in your case, and then talk to you about certain limitations that might exist. For example, if you've applied for a mental health claim and there are several references in the record to overdoses or drug and alcohol abuse, those are two big things that Social Security will really scrutinize. And so having an attorney who has seen that in the records and can kind of help you try to proactively combat that can be helpful. It's important to note that anytime an attorney is asking you these questions, we're doing it from a place of caring, a place of trying to help you. So that's important to note, that, sometimes these medical records do say things we don't want them to say. Sometimes the medical records truly are not correct, and sometimes they are. And it's important that you're always honest with your attorney as to whether the records are correct or not, and what you can do to kind of go about working with those. So that's a huge benefit to having attorneys. We do review your medical records. And if there is kind of something in there that might be a problem, we generally will have that conversation with you. So that way, no one's blindsided by it in the hearing is the other benefit. To that end, we help prepare you for that hearing with an administrative law judge. Sometimes we do the questioning, sometimes the judge does, but either way, the law firm and the attorney can generally help you prepare and help you understand what to expect. You're still under oath. It is still a professional proceeding. So it is still nerve-wracking. There's nothing that an attorney can do to totally take that away. But there is a lot that we can do to kind of help prepare you and let you know what to expect. Finally, we can question you and any witnesses during your hearing. Each hearing office has different rules and restrictions on witnesses, but some of the most common witnesses that are present at never say all, most adult hearings are a vocational witness. And so your attorney may have questions for him or her. Same with a medical witness. The attorney will likely have questions for him or her. And then any witnesses that the judge has allowed you to bring on, time permitting. Your attorney may also talk to you about other ways to get witness testimony in without having a witness live present in the room for you. Again, as promised, at the end of the webinar, I'd give my contact information. You can give me a call, send us an email. Again, Social Security, we can assist clients throughout the United States. I am a Florida barred attorney. Our office is in St. Johns County, Florida. But if you have questions about anything, feel free to reach out, give me a call, send me an email. Happy to help, happy to answer any questions that you've got. Thank you so much for your time, and I'll talk to you soon.